A unanimous federal court decision just dropped on suppressors, and right before it landed, the Department of Justice completely flipped its own position. But here's the shocking twist. Now the DOJ is fighting back hard, and the NFA is caught right in the middle. Quick question before we continue. Are you subscribed yet? Because what I am about to walk you through could directly affect whether you legally own a suppressor or end up facing federal charges. Hit that subscribe button right now. I do not want you missing a single update on this. Okay, so let us start from the very beginning, because this story has a lot of moving pieces, and I want to make sure you understand every single one of them. Let us go back to February 2025. There's a case called United States versus Peterson. It went before the Fifth Circuit Court of Appeals. Now, the Fifth Circuit is one of the most powerful federal courts in the country. Their decisions affect Texas, Louisiana, and Mississippi directly, but their rulings send shockwaves across every gun owner in America. In February 2025, a three-judge panel at the Fifth Circuit ruled that suppressors, the devices that reduce the sound of a gunshot, are not protected by the Second Amendment. Their reasoning? They said suppressors are not actually arms. They argued a suppressor is just an accessory. It is not something you need to operate a firearm, so it does not count as a protected weapon under the Constitution. Now, most gun owners heard that and felt their stomach drop, because if suppressors are not protected, then Congress can regulate them however they want. The government can restrict them, tax them, and bury them under mountains of paperwork. And that is exactly what the National Firearms Act, also known as the NFA, has been doing since 1934. Here is what the NFA does, in simple terms. If you want to own a suppressor legally, you have to register it with the federal government. You have to fill out forms. You have to pay a tax. And you have to wait months, sometimes over a year, for approval. Until recently, that tax was $200 every single time a suppressor changed hands. So that February ruling was bad news. It basically said, yeah, the government can keep doing all of this, and most people accepted it and moved on. But then something big happened. In June 2025, everything changed. The DOJ, the Department of Justice, which is the federal government's top law enforcement agency, reversed its own position. Let me say that again. The DOJ flipped. They changed sides. They went from saying suppressors have no Second Amendment protection to admitting that suppressors might actually be protected arms under the Constitution. That reversal forced the Fifth Circuit to act. On June 17, 2025, the Fifth Circuit officially withdrew that February ruling. They pulled it back completely, thrown out, gone. The Firearms Policy Coalition, or FPC, which is a major gun rights organization that backed this case, called it a massive win. But here is the part that most people are getting confused about. The court did not just say, okay, suppressors are protected, everybody goes free. It is more complicated than that. The unanimous new ruling, all three judges agreed on this, assumed without formally deciding that suppressors are protected by the Second Amendment. Think about that wording carefully. They said they would assume it is true. They did not officially declare it as the law, but they assumed it for the purposes of this case. That is actually a huge shift in legal language. And yet, even with that assumption, the court still upheld the conviction in the Peterson case. They found another legal path to keep the ruling against Peterson standing. So the defendant lost his case, but the legal landscape for every other gun owner in America shifted significantly. If you are finding this helpful, imagine what you will learn in my next video. I am going to cover exactly what you should say and do if law enforcement questions you about your NFA items. You do not want to miss that one. Hit subscribe right now so it lands directly in your feed. Now, let us talk about the other giant piece of this story, because it connects directly to why the DOJ flipped in the first place. On July 4th, 2025, President Trump signed what is known as the One Big Beautiful Bill into law. And buried inside that massive piece of legislation was a game-changing provision for gun owners. Congress eliminated the $200 NFA tax stamp, completely zeroed it out. As of January 1st, 2026, if you are registering a suppressor, a short-barreled rifle, or certain other NFA items, you no longer pay that $200 federal tax. That is the first time in nearly 90 years that tax has gone away. It has been there since 1934, and now it is gone. For gun owners, that sounds like a massive win, and it is. But here is where the legal battle gets really interesting. And this is the part nobody is talking about loudly enough. The NFA was originally justified as a tax law. Back in 1934 and again in 1968, Congress and the courts defended the NFA by saying, yes, we are taxing certain dangerous weapons. The registration system exists to collect that tax. The Supreme Court agreed back then. The taxing power of Congress is broad, and that is how the NFA survived legal challenges for nearly a century. But now the tax is gone. So here is the question that gun rights lawyers are raising in courts across the country right now. If the entire legal foundation of the NFA was tax collection, and there is now zero tax to collect, is the NFA still constitutional? That argument is at the heart of a major lawsuit called Silencer Shop Foundation versus the Bureau of Alcohol, Tobacco, Firearms, and Explosives, or BATFE. That lawsuit was filed on July 4th, 2025, the same day the big, beautiful bill was signed. The timing was not a coincidence. The plaintiffs argue it simply and directly. The law said you must register your suppressor so the government can collect a tax. The tax is now zero, so the registration requirement has no constitutional leg to stand on. The court should strike it down. Now, quick legal note right here. Everything I am telling you is educational information. It is not legal advice for your specific situation. Gun laws are complicated and they change fast. Always talk to a qualified firearms attorney if you have questions about your personal situation. Okay, back to the story. The Silencer Shop case is moving fast. Both sides have filed their summary judgment motions. That means both sides are asking the court to rule in their favor without a full trial. The 6-3 conservative majority on this court has already proven it is willing to expand gun rights. They did it in 2022 with the Bruen decision, which struck down New York's concealed carry restrictions. They did it in 2024 with other rulings. And based on what the justices are saying publicly and in their written statements, assault weapon bans may be next on the chopping block. Now, this is where it gets interesting, because the Supreme Court is only half of the story. The other half is the Department of Justice, and what they are doing right now is absolutely historic. If you are finding this helpful so far, imagine what else I have coming. My next video breaks down the exact words you should say when a police officer asks about your firearm during a traffic stop. Words that protect you legally. Subscribe right now so you do not miss it. Let us talk about the DOJ. On December 22nd, 2025, the Trump administration's Department of Justice did something that has never happened before in modern American history. The DOJ sued Washington D.C. over its ban on AR-15s and other semi-automatic rifles. Let that sink in for a second. The federal government, the United States Department of Justice, went to court to fight for your right to own an AR-15 in Washington, D.C. itself. The DOJ's lawsuit says D.C.'s ban is unconstitutional. It says that AR-15s and semi-automatic rifles are in common use by millions of law-abiding Americans. The DOJ pointed out that the AR-15 is one of the most popular rifles in the entire country. Tens of millions of Americans own one. When a firearm is in common use by law-abiding citizens, the Supreme Court has said the government cannot simply ban it. That is the Bruen standard. That is the Heller standard. And that is exactly the argument the DOJ is using. But wait, there is something even more important. The DOJ did not stop at just suing D.C. In June 2025, they also filed what is called an amicus brief, basically a legal document saying, we agree with this side. In a case called Barnett versus Raoul, that is the challenge to Illinois' assault weapon ban. The DOJ told the court that Illinois' ban on commonly used rifles and large capacity magazines is unconstitutional. They used plain, powerful language. They called these firearms some of the most commonly used rifles and magazines in America. Now, quick legal note. This is educational information, not legal advice. Everyone's situation is different. Always talk to a licensed attorney for your specific circumstances. What I am giving you here is the big picture so you stay informed. Here is why this matters so much. When the DOJ files these lawsuits and these briefs, it changes the legal battlefield completely. Courts pay attention when the federal government walks in and says a law is unconstitutional. It carries enormous weight. And right now, the federal government is using that weight to fight for the Second Amendment. Here's the part nobody is talking about. The DOJ, under the Trump administration, actually created a brand new section specifically for this. It is called the Second Amendment section within the Civil Rights Division. Think about that. The same division of the DOJ that fights for civil rights now has an entire team dedicated to protecting your Second Amendment rights. They are filing lawsuits. They are filing briefs. They are building cases. They are doing it fast. Here is a hypothetical example to explain why this matters on the ground level. Imagine you live in Illinois. You own an AR-15 that you bought legally before the 2023 ban. Under Illinois law, you're now required to register it with the state or face serious criminal charges. But a federal court struck down that ban is unconstitutional. Then a higher court reversed that decision. Meanwhile, the DOJ files a brief saying the whole thing is unconstitutional. You are caught in the middle of all of this, not knowing what the law actually is where you live. That is the reality for gun owners in multiple states right now. This is why staying informed is not optional. It is survival. Hey, take a quick look at the viewer count right now. Statistically, about 73% of people watching this video are not subscribed. That means most of you are at serious risk of missing the next update when a new ruling drops, when a new lawsuit is filed, when a new law gets struck down. Do not be part of that group. Join the 50,000 gun owners who already get these updates first. Hit subscribe right now. Now let us talk about where all of this is headed. Multiple assault weapon ban cases are currently moving through the federal court system. Illinois, Maryland, California, Washington State, Washington D.C. The Barnett case in Illinois is especially important because the lower court had already struck down the ban, meaning a federal judge already said it was unconstitutional. Then the state appealed and things got complicated. But the DOJ is right there, fighting to keep those bans down. Here's what the Second Amendment actually says in plain English. It says the right to keep and bear arms shall not be infringed. Period. Full stop. The Supreme Court has said that right covers weapons in common use by law-abiding citizens for lawful purposes like self-defense. An AR-15, with tens of millions in circulation, is clearly in common use. The legal argument for banning it is getting weaker and weaker every single day. Here's what the states with assault weapon bans are doing. They are arguing that AR-15s and similar rifles are military-style weapons and are too dangerous for civilians. But here's the truth that blows that argument apart. The AR-15 is semi-automatic. That means one trigger pull equals one bullet. The actual military does not even use the AR-15. The military uses fully automatic rifles. The name AR does not stand for assault rifle. It stands for Armalite rifle, named after the company that designed it. The fear around the name is just that, fear, and the courts are starting to see through it. Justice Kavanaugh's statement in the Snope case made this point crystal clear. He wrote that the question of whether assault weapon bans are constitutional is important and recurring. Translation, this is coming to a head. It is not a matter of if the Supreme Court takes this up. It is a matter of when. This information could change dramatically before the end of 2026. New rulings are coming. New cases are being decided right now. Subscribe immediately because my next video will cover exactly what gun owners in states with assault weapon bans need to do before the next major deadline hits. Do not miss it. So let us wrap this up. Here is your bottom line. The Supreme Court's 6-3 conservative majority has sent a clear signal. Assault weapon bans are on very shaky legal ground. Justice Kavanaugh has basically said the court needs to step in and settle this issue once and for all. At the same time, the Trump DOJ has gone to war against these bans. They are suing D.C. They are filing briefs in Illinois and other states. They created an entire new team inside the DOJ just to fight these battles. The momentum right now is strongly in favor of gun rights. This could lead to a Supreme Court ruling that strikes down every assault weapon ban in the country. But here's the thing. The fight is not over yet. Lower courts are still divided. States are still enforcing their bans while the legal battles play out. If you live in a state with an assault weapon ban, know your current state law. Know what is registered. Know what is restricted. Do not assume you are safe just because these legal challenges are winning. If this video helped you understand what is happening, do me one small favor. Hit that subscribe button and ring the notification bell. I put in hours of research every single week so you never have to guess about your rights. The gun rights landscape is changing faster than at any point in modern history, and I am going to be here for every single development. You should be too. Quick legal disclaimer. Everything in this video is for educational purposes only and reflects publicly available legal information and news. It is not legal advice. Gun laws vary by state and change frequently. Always consult a licensed firearms attorney in your state before making any decisions about what you own, carry, or how you comply with local laws.